Right, folks, welcome to SQE One Window, and we are going to start today, Mother of All Private Laws. So, this is Chapter 1 of Contract Law, the foundation stone of everything we will study for the SQE. It talks about most of the areas of private law. Like, think of contract as the legal glue that holds everyday life together. From your Netflix subscription to your tenancy agreement, you are constantly entering contracts. Some knowingly, some after ignoring the small print entirely, small fonts and all. So careful next time you sign a contract. So what is contract? So in order to understand contract, we need to look at, like, in simple term, it is a legally binding agreement, and it's a promise or set of promises which the law will enforce. So, sounds neat, but the devil, as ever, is in the detail. Like, it's kind of like, it looks very easy, it's a promise, but it got a load of layers in it. That's what we will try to simplify, all those layers. Not every promise to take tea or lend a pen will bind you in court, although some of us might wish it did. For example, if I invited someone to have a cup of coffee at 6 and I don't turn up, it does not mean they can straight away take me to the court for enforcement of that contract. So, building upon that, now for an agreement to become contract, 3 essential ingredients must be present. A bit like the flour, egg, and sugar for the legal cake. So first, there must be agreement, which comes from offer and acceptance. One side makes a clear offer, another side says yes to those exact terms. Same, and that's called mirror rule. Same offer meets an acceptance and agreement forms. Second is intention to create legal relations. The law asks, did the party means to be legally bound, or were they just chatting about Sunday roast? So we need to differentiate between legally binding relations and domestic relation, and we will talk about it in detail. And third, consideration, which means each party gives something of value. It could be money, service, or even a promise to do something. Without consideration, a promise is just polite conversation, not a contract. So, other essential elements that we need to look at. Life would be too easy if those 3 were enough. For example, offer, acceptance, and consideration. The law adds a few more hurdles. We have capacity, for example, meaning that both parties must be capable of contracting. Children, intoxicated persons, and mentally incapacitated often get special protection. Then there is consent. No one should be bullied, tricked, or misled into a contract. The law has no time for strong arming or shady deals. Next is legality. Your contract must have a lawful purpose. You cannot sue for breach of a drug dealing agreement that I signed, no matter how entrepreneurial or profitable that looks. Form is another. Some contracts, like deeds or guarantees, must be in writing. For example, if you are buying a property, it must be in writing, and that is Law of Property Act. We will be talking about it in other videos. Others can be entirely verbal, which is fine until someone denies what was said at that point. So, and finally, certainty of terms. The court must know exactly what has been agreed. If it cannot make sense of the terms, the contract collapses, as it was in Scammell versus Austin. So at that point, you need to understand it is not only offer, acceptance, in consideration, and that's a contract. So load of other things if it is asked in your SQE questions. So just have a look at all those elements, essential elements of contract. So classification. How to classify contracts? Like contracts come in different flavors. For example, the most common is bilateral. Both sides make promise, I will sell you my car and you will pay me £5,000. It is a fair exchange unless it turns out to be a 1998 Ford Fiesta with a missing wheel. So there are unilateral contracts where only one side promises something in return for an act, and believe me, it is a concept students find it very hard. Even I found it hard to understand. But the classic case is Carlyle versus Carbolic Smokeball Company case. So poor Miss Carlyle used the company's miraculous flu prevention ball and still caught the flu. The company had promised £100 to anyone who used it and still fell ill. She claimed it and won. Proof that sometime even sniffles can lead to legal glory. Yes, it is. So that's unilateral promise. And another example can be that if I miss my beloved cat, a pet that I got at my home, I'm not telling you her name, if I miss her, so I can just post an ad, whosoever bring back, I will pay £50 to that person. So at that point, I'm making to the world a unilateral promise. So that will be done by performance. If they bring it back, I would have to pay them money, and that's not a puff. That's a real thing I have promised to people at the lodge. So another way to divide or classify contract is by form and performance. Formal contracts like deeds must follow strict legal requirements, usually written, signed, and witnessed. Simple contracts do not need such ceremony. A handshake will do. That's it, though it is harder to prove in contract. Then there are common question of timing. An executed contract has already been performed, which was performed already. Think of buying a sandwich, instant exchange, no fuss. An executory contract is still to be performed, like agreeing to pay for your sandwich next week, which incidentally makes you a terrible customer. Never ask. Say. The next is enforceability of contract. Not all agreements are created equal. We have three main categories of enforceability. A void contract is a complete non-starter. It never existed in law. You might as well have promised to build a castle in the cloud. So, that was not a contract at all. You can't do that kind of contract. A voidable contract starts valid, but can be cancelled by one party. Common reasons include misrepresentation or duress. The wronged party can choose to avoid it or take it. An unenforceable contract is perfectly valid in theory, but cannot be enforced, often because of a technical error. For example, an oral contract of sale of land, the law insists that such agreement must be in writing. So when reading a problem question, always ask, is this contract valid? Is it void? Is it voidable or unenforceable? The question alone can earn you a precious mark, and sometimes 2 or 3 marks as well, if there are a load of questions on the same topic. So, what is role of contract in contract formation? You need to understand how do courts decide whether a contract exists or not. They use the objective test, and that test is examined sometime. That means they do not care what was going inside your head. They care about the reasonable person would think from your word and action, what they think, like what you were doing in that condition. You might insist, I was joking, but if your conduct looks like a serious offer, the court may hold you to it. That's it. In other words, do not promise your friend your car in jest after a night out and accept the judge to laugh at you later, for example. So be careful in making promises. The objective approach keeps the system fair and predictable. It ensures that people can rely on appearance of promise. So it is not what you think or interpret, it is what things tell and speak for a common man around you, So at that point, courts will not listen to you more. They will look at circumstances and how it can be interpreted by an ordinary reasonable person. So the next thing is common pitfalls in contract formation. Let's face it, contract formation is a minefield. Student and even practicing lawyer fall into the same trap again and again. First, unclear offers. If the terms are vague or incomplete, they might be mere invitation to treat. Think of goods displayed in shop. They invite you to make an offer on the till. They are not offered themselves. Otherwise, sometimes I've found things misplaced at other price tags, and then I think, oh, hooray, I got something. So things on the shelves or aisles are not offer. It is you who take them, and those are invitation to treat. You take them to the till and make an offer. Yes, I want to buy it. That's accepted. Pay the money, take it, and go home. Second, assuming casual promises are binding. I promise I will pay you back next week, for example. At the pub is that kind of promise at the pub is rarely a legally enforceable statement, unless of course you put it in writing and charge interest. So it does not work. You pay for my drink now, maybe I'll pay it later for you as well. So that's not a legally binding promise. Third, capacity. There are capacity issues. Contract with minors or people lacking mental capacity can be voidable. They are not void, but those are voidable at the option of weaker party. Fourth, oral agreement, perfectly valid, but very risky. When memory fades or people change, always get it in writing. And finally, illegality. You cannot rely on a contract that involves breaking the law. So you cannot enter into a contract of selling drug, no matter how clever the business idea you got it. So you can't have dealing in legal dealing in illegal businesses. So now for some SQE survival tips like I got. And number one, always start formation question with the golden formula. Offer plus acceptance plus intention plus consideration. It is a magic key to unlocking full marks. Understanding what contract is or it is not a contract. Learn to distinguish between voidable and unenforceable contracts. In exam, they love it. Tip number 3, use case names wisely. If there are some case names, Carlyle, Scammell, and Balfour versus Balfour are your best friends. Drop them like clever confetti in your answer. But not too many, or you will sound like you swallowed a law report. Never. And most of the time, they don't check your knowledge of all those cases. Remember, intention is judged objectively. The court does not care about your personal or anyone's personal feeling. Tip number 5, do not assume anything must be written. Some contracts can be oral, except where the law demands in writing, for example, lender guarantees. Tip number 6, when revisiting, test yourself with everyday scenario, things which are going around you. The law of contract is everywhere, your gym membership, phone contracts and everything. So to just sum up the building blocks of contract law, in next session we will try to just look at offer and exception. So that's what it is. So bring your attention and your curiosity to our next session. Thank you very much for listening to us, and we'll try to make contract law easy peasy lemon squeezy for you. Ta-da!